If you were just fired or you think you might have been wrongfully terminated, I need you to watch this video before you do anything else. Because there are 5 mistakes that employees make after getting fired that completely destroys their legal case. And most people have no idea they're making them. Some of these feel totally harmless in the moment, even responsible. And they get worse as we go on, so stick with me. The last one is the one your employer will actively pressure you into. They're going to make it sound like it's in your best interest. And they're counting on the fact that you're going to be stressed and that you won't push back. Don't let that happen. Quick disclaimer, I'm Manny Starr, Managing Partner at Frontier Law Center. We're a California employment law firm, and this video is for education, not legal advice. Every situation is different, so if something I say sounds familiar, talk to an attorney who can actually look at your case. Okay, let's get into it. Mistake number 1, assuming at will means you have no rights. This first mistake happens before most people even know they have a case. And it's this. They hear, California is an at will state, and they stop right there. Your employer loves to say that. They say it with this calm confidence, like it's a magic spell that makes all your rights disappear. And here's what they are not telling you. Yes, at will means your employer can fire you without reason, without notice. That part is true. But at will means any legal reason, not any reason. And there's a long list of reasons that are flat out illegal in California. Here's how that plays out in real life. An employee complains to HR that her manager is making sexist comments. The manager fires her. Now, he is not going to walk into that deposition and say, I fired her because she complained about harassment. What he's going to say is, she wasn't a team player, she was insubordinate, she was late a couple of times. Those sound like legitimate reasons, and that's exactly the point. The fake reason is the cover story for the real one. In employment law, we call that pretext. It's a dishonest explanation, a lie rather than an error. And employers almost always have one ready. They have HR departments and legal teams whose entire job is to come up with these explanations. Your job, and your lawyer's job, is to show that those reasons are the cover story, that the real reason was something illegal. So when someone tells you they can fire you for any reason in California, they're technically right. But they are hoping you walk away thinking you have no options. You might have very significant options. Don't count yourself out before you talk to someone. 2, waiting too long to get advice. This is the mistake that costs most people their cases, and they don't find out until it's too late. Here's what typically happens after someone gets fired. The first few weeks, they're just processing. Then they start job hunting. A few months go by, the situation starts bothering them again. They Google it, they call an attorney, and sometimes by then, the deadline has already passed to bring a case. Employment claims in California have hard filing deadlines, and they start running the day you're fired. Not the day you figure out what happened, not the day you decide you're ready to deal with it. For federal discrimination claims under laws like the Age Discrimination Act or the Americans with Disabilities Act, you have as little as 180 days to file a charge with the EEOC. That's 6 months from the day you were fired. For California discrimination and retaliation claims, you have 3 years to file with the California Civil Rights Department. Workers' comp retaliation, 1 year. 3 years sounds like a lot, but between the investigation process, building your case, and honestly just processing what happened to you emotionally, it goes fast. The most difficult calls we get at Frontier Law Center are from people who had strong cases, real violations, clear evidence, but they waited too long. Once that deadline expires, there is nothing anyone can do for you. Not us, not anybody. If something feels wrong about how you were let go, just get a free consultation. Do it now, not next month. 3, talking too much after you get fired. This one comes in 3 forms and they all lead to the same place. 1, the exit interview. The last day comes and HR asks to sit down. They call it a casual conversation, just feedback to help them improve. It sounds harmless. It might even feel cathartic. You finally get to say everything on your mind, but don't do it. Anything you say in that meeting gets documented and goes in your file. If you later file a legal claim, that documentation comes out. If you told them, I'm leaving to find new challenges, or it was just time for me to make a change, and that real reason you left was that you were being pushed out or discriminated against, the exit interview just became the defense's best piece of evidence. They will wave it in front of the jury and say, look, in her own words, she said she left because of this, and it had nothing to do with discrimination. You have zero legal obligation to do an exit interview. You can simply say you're going to pass. You don't need to explain yourself. 2, social media. I know you want to vent. You just got fired and you're angry, and that makes complete sense. But what you post publicly can be used against you. Just hold off until you talk to someone. Instagram will still be there. 3, texting coworkers. Be careful here too. If you're reaching out to people from work, asking questions or venting through the work apps, those conversations can be subpoenaed. Keep your discussions with people you trust and off those channels. There's a way to think about all this. Every time you're deciding what to do or say in one of these situations, just ask yourself, How would this look to a jury? It sounds dramatic, but that question will protect you more than almost anything else I can tell you. Mistake 4, not documenting what happened while you still can. Memory is not reliable. I know that sounds blunt, but it's true, and I've watched it hurt cases. Right now, you remember everything, the exact conversation, who was in the room, what your manager said, what reason they gave you, what happened in the weeks leading up to it. But 3 months from now, the details will blur. Not because you're not paying attention, just because that's how memory works under stress. And the other side will have documents. So here's what you need to do, and do it today if you can. Write everything down. Every conversation you remember, every date, who was present, what they said, the reasons they gave you, any events in the weeks or months before that felt relevant. A complaint you made, a leave you took, a performance review that suddenly turned negative. Then save everything you have. Emails, texts, performance reviews. Save it somewhere that you control. On your personal phone, your personal email. Your work email access is probably already gone. And here is something most people don't know. In California, you have a right to request your own personnel file. You can ask your former employer in writing for your employment records. That file may have documentation that matters to your case, including write-ups that you never knew existed. One more thing in this section, pay attention to comparators. Were other people at your company doing the same thing that you were, coming in late, missing deadlines, having attitude issues, and still keeping their jobs? If the answer is yes, and you are the one who got fired, that's meaningful. It suggests that the reason they gave you is not the real reason. Build your record while it's still fresh. It could be the difference. Mistake 5. Signing the severance agreement before you know what you're signing. Okay, here it is, the one I told you about at the start. On your last day or shortly after, a stack of papers appears in front of you. Your employer knows you're stressed. They know you're not going to read every word, and they are counting on that. Somewhere in that stack is a document that says if you sign, you agree to give up your legal rights to sue them for anything. Discrimination, retaliation, wage theft, wrongful termination, all of it gone. In exchange for a few weeks of severance pay. And then comes the pressure. This offer expires today. You need to sign this to receive your final check. It'll be cleaner if you do it this way. The termination will follow you. This protects your record. Let me be direct about this one. That line about how it will look on your record is not true. Future employers almost never verify whether you were fired or resigned. They confirm the dates of employment and your job title. That's it. Your employer is using your fear against you. Here are the magic words, and I want you to actually remember this. I need to have an attorney review this before I sign anything. That's it. You don't need a long explanation. You don't need to be aggressive about it. You don't need to apologize. Just those words. You're not asking for anything unreasonable. You're simply protecting yourself. Now, here is something your employer definitely will not tell you. In California, if you are over 40 and the severance agreement includes a waiver of age discrimination rights, you are legally entitled to at least 21 days to review before signing it. And then 7 days after you sign it to change your mind. That's the law. They cannot take that time away from you. Even if you're under 40, you still have the right to take time before signing. They may push back, that's okay, push back on them. Severance agreements are not automatically bad. Sometimes they offer fair compensation, but the only way to know what you're giving up is to have someone look at it who actually understands what's in it. At Frontier Law Center, our initial consultation is free. If someone puts a severance agreement in front of you and tells you to sign it today, please call us first. Let me give you a quick version to take with you. Mistake 1, assuming at will means you have no rights. It doesn't. The fake reason is almost never the real reason. Mistake 2, waiting too long. The clock starts the day you're fired, not the day you're ready. Mistake 3, talking too much. Exit interviews, social media, work texts. Less is more until you've spoken to an attorney. Mistake 4, not documenting while it's fresh. Write it down, save everything. Request your personnel file. Mistake 5, signing the severance agreement without a review. 5 words, I need an attorney first. Your employer has lawyers. Their HR team is trained on all of this, and they are counting on the fact that you aren't. Now you are. If something about your situation feels off and you want to talk through it, you can reach us at frontierlawcenter.com. Free case evaluation, no pressure. And if you found this helpful, like this video and subscribe. Every week we put out content on the California employment laws that protect you, because the more employees understand their rights, the harder it is for employers to get away with violating them. I'll see you next week.